So good afternoon. Charlie and I are delighted to be here today to talk to you about the latest developments in trade secrets. Trade secrets are particularly important to companies who innovate, and so will typically form an essential part of any tech company's IP strategy. Trade secrets can protect valuable assets that may not fulfill the strict criteria for other IP rights. So here, thinking about things like test results, manufacturing processes, data sets, and even algorithms, along with commercial information such as pricing, supplier ecosystem information, customer lists, and marketing plans. But innovators are increasingly relying on trade secret protection, even in place of other rights, for important strategic reasons. In particular, the fact that no disclosure is required to qualify, and the potential for protection to last indefinitely are seen as highly attractive features. So it's not really surprising that we're seeing such a significant increase in trade secret litigation from tech companies seeking to protect their innovations, but also an increased demand for advice on how best to avoid misappropriation and misuse of trade secrets in the first place.
So over the next 20 minutes, we're going to look at several emerging trends that we've been seeing in global trade secrets litigation in the past year, and highlight some practical steps that you can take to ensure your trade secret policies and strategies remain robust in light of these developments. Before we dive into the trends, it's worth briefly reminding ourselves of the fundamentals. So what exactly are trade secrets? In the UK, trade secrets are protected by a combination of the common law of confidentiality and the Trade Secrets Regulations 2018, which emanated from the EU Trade Secrets Directive. And looking more globally, all World Trade Organization member countries are required under the TRIPS agreement to provide protection for trade secrets. The specifics differ from country to country, but the core criteria are generally consistent. First, the information must be genuinely secret, meaning it isn't generally known or readily accessible to people who normally deal in that type of information. Second, it must have commercial value because it's secret. And third, the owner must have taken reasonable steps in the circumstances to keep it secret. In practical terms, this means if your business creates or gathers valuable proprietary information, the sort of thing competitors would be willing to pay for, and you actively maintain its secrecy through appropriate measures, that information may be eligible for trade secret protection.
So the first trend that we've identified in the past year or so has been an increased number of claims for trade secret misappropriation by companies who were exploring a potential collaboration, such as a tech licensing deal, or were in the process of being acquired. And during that process, there was disclosure of trade secrets. But the deals under discussion didn't come to fruition, only for the other party to go ahead and release its own version of the technology that was being discussed shortly thereafter. The fact that we're seeing an increase in litigation of this nature makes sense, because it seems that there's more collaboration and acquisitions in the sector than ever. Even in recent weeks, for example, we've seen announcements from NVIDIA. It's investing $1 billion in a joint project with Eli Lilly for an AI-enabled drug lab, and even the Apple and Google deal on Gemini to support Siri. So with tech innovation taking place at a breathtaking pace, in order to retain a competitive edge, it can often be quicker and less risky to license in tech or acquire a tech startup. But these relationships, if they don't go ahead or they don't last the distance, can come with significant risks. Whereas part of that process or that relationship, confidential information has been disclosed and shared with parties who may, in the end, be your competitors. So a good example of a case we've spotted concerning a failed tech licensing deal was heard in the Arkansas Federal Court. It was brought by Zest Labs against Walmart and had been running on for many years, but was finally decided this year, last summer. So Zest Labs is an agri-tech startup, and they were providing technology solutions for food and delivery management to reduce food waste. Zest and Walmart spent several years exploring a potential licensing deal under an NDA which included Walmart trialling Zest's food preservation technology. During this time, a large number of Walmart's employees gained access to Zest's trade secrets, including trade secrets, among other things, including algorithms, data, and process know-how for this food tracking freshness technology. Walmart, in the end, terminated the collaboration, said it planned to build its own system, but the very next day filed a provisional patent application using Zest's confidential information. Zest was successful in its trade secrets claim in May 25 and was awarded over $200 million in damages, as Walmart were found to have willfully and maliciously stolen trade secrets. The successful outcome was no doubt influenced by the fact that Zest had taken important precautions to maintain the secrecy of its information, such as entering into NDAs with its employers and with Walmart, and as soon as they suspected wrongdoing, sent a series of escalating warnings to Walmart.
So another significant case we saw last year is Propel Fuels and Phillips 66. Propel Fuels is a small startup producing low-emission, high-performance renewable diesel fuel. Back in 2017, Propel entered discussions with Phillips 66, a company described in this case as an oil and gas behemoth, which sell fuel through a network of gas or petrol stations. Those discussions were about a possible acquisition or a joint venture. Extensive due diligence followed, in which Propel shared detailed confidential information under an NDA, including information about its fuel technologies, its business strategies, and its financial data. Then, in 2018, Phillips abruptly walked away, opting instead to go it alone. What followed was a particularly stark example of trade secret misappropriation. Phillips rapidly developed its own renewable diesel business, was found to have shaved years off its market entry by using the information it had obtained from Propel. Not only did it fail to destroy the trade secrets it had received during negotiations, it also made no attempt to ring-fence a separate, clean team to develop its competing product. In fact, evidence showed that Phillips had taken one of Propel's spreadsheets and used it directly to greenlight its go-it-alone strategy. The result was a finding of misuse of 77 trade secrets and one of the largest damages awards for trade secret infringement ever made. A staggering $604 million in compensatory damages, $195 million in exemplary damages, and prejudgment interest on top. So with transactions like these continuing at pace in the tech sector, let's look at what we can learn from these cases and what practical steps companies should take to protect themselves in these deal processes.
So when you are the company sharing your trade secrets, you should be thinking about at least two of the following. So first is entering into a robust confidentiality agreement before any information is exchanged. It was important in both of the cases that we've just spoken about that there were NDAs in place, and the plaintiff in question was able to bring a claim in contract as well as under the local trade secret laws. An NDA is also a really important way to demonstrate that you've taken reasonable steps, going back to that original slide that Charlie mentioned, to safeguard the information. But in order to ensure this actually happens, it's important to bake in this requirement for NDAs into company policies and to regularly reinforce with employees, with business people, that it will be, for example, a disciplinary matter if they fail to put in place proper measures to protect the company's innovations in accordance with your company policies. It's not unusual for highly confidential projects for a trade secret owner to insist that disclosure is limited to a small identified group of people to avoid losing control of that information, and even asking those individuals to sign their own declarations that they've read and understood the NDA, and this can be very helpful in focusing minds. In your NDA, there should also be a very clear obligation for what happens on termination of a deal or a collaboration. And you need to be ready to follow up on those and insist on evidence of destruction or deletion of such materials. Second, it's important as a business that there is an understanding of what company information may qualify as a trade secret, and in turn to educate employees on what it is they are expected to safeguard in these situations. In some of the other trade secrets cases that Charlie and I have come across from 2025, the courts refused to grant injunctions, or they were later overturned because the applicant wasn't able to identify the trade secrets alleged to have been misused with sufficient precision. When you are the company looking to license in another's technology or to acquire another company, it's important to have a policy or clear guidance for employees in the event that potential collaboration or acquisition does not work out. For example, if you've decided to go it alone and to develop your own equivalent technology, you need to ensure those involved understand that this needs to be done using a clean team. This typically means any tainted employees aren't allowed to work on the new project, and ensuring that you haven't retained any third-party confidential information which could contaminate your clean environment. This helps reduce the risk of inadvertently using someone else's trade secrets, and also can be highly effective in fending off potential allegations later down the road that trade secrets have been misused to accelerate any development. It's also very useful, we found in the past, if clients keep clear records and a timeline of their own product development, so that evidence can be produced in due course to demonstrate it was conducted independently and without reference to anyone else's confidential information.
Right, so the next trend we've been seeing comes about as a result of employee mobility in the sector. Employees moving to competitors has long been one of the major sources of trade secrets disputes, and 2025 was no different. We saw a typical example of this last year in the English High Court, a claim brought by Playtech Software, an online gaming company. A senior Playtech games developer had access to a platform called Horizon, which hosted playable versions of Playtech's games, including as yet unreleased titles. After leaving Playtech, he joined a competitor, Games Global, in a very similar senior development role. Sometime later, Playtech discovered he'd retained his login credentials and had continued to access the Horizon platform, and they suspected this was to inform his development of competing games for his new employer. Playtech issued claims against both the former employee and against Games Global for misuse of confidential information, misappropriation of trade secrets, and copyright infringement, and those proceedings are still ongoing. But what we're now seeing more often are cases where tech companies allege that competitors have deliberately targeted and recruited whole groups of employees who then take or continue to access their trade secrets to accelerate the development of competing technologies. Sometimes this use of a previous employer's trade secrets happens with the new employer's knowledge, sometimes it happens without it, but the pattern is becoming increasingly common. This targeted recruitment is particularly acute in the tech sector because the talent pool for many of the emerging technologies we're seeing is limited and highly specialized. And in areas like biotech and AI, employees often have extremely specific and highly desirable skill sets tailored to those areas. But when any employee is recruited by a direct competitor, there is an obvious risk that trade secrets and confidential information might follow with them, whether intentionally or sometimes inadvertently.
So, a recent example of this type of sort of targeted mass recruitment can be seen in a case brought by Qorvo. And they are a leader in the sphere of wireless and wired connectivity technology, and they brought an action against their competitor, Akoustis. Qorvo alleged that Akoustis had strategically targeted and recruited over 20 of its employees across all roles, from engineering and operations to sales, testing, and management, for the specific purpose of using the confidential information they gained from their employment at Qorvo to develop a competing wave filter technology. While the experience and skills gained by employees in the normal course of their employment are generally not considered to be trade secrets, Qorvo was assisted in its case because they were able to prove that various of these employees who'd moved over had taken a significant number of confidential documents containing designs and specifications for its technologies, manufacturing process techniques, inspection procedures, and technical know-how. During disclosure, it in fact came out that during the recruitment process, Akoustis had directly asked the employees to screenshot confidential information prior to them. So it was perhaps unsurprising that Akoustis was found to have willfully and maliciously misappropriated 37 trade secrets to develop their own competing technology, and they were ordered to pay damages of $39 million.
So one of the key reasons Qorvo succeeded in its case was its ability to show that it had taken extensive, structured steps to safeguard the secrecy of its proprietary information. Qorvo restricted access to its confidential documents within its document management systems. It clearly labeled those documents as confidential consistently. It had required employees and any other recipients to sign agreements containing non-disclosure obligations, and it was able to show that as part of its exit process, it had reminded those departing employees of their duty to return all confidential materials and to maintain confidentiality. On top of that, Qorvo provided all its employees with a comprehensive handbook setting out its confidentiality policy, which specifically addressed the protection of its trade secrets as well as other sensitive material. Qorvo also put in place robust technical security measures. These included quite extensive password protection protocols, not only for devices, but for individual workspaces, unique passwords assigned to particular roles and to specific folders. And it had IT systems capable of monitoring and detecting unauthorized access to any system containing confidential information. In short, this was a company that had taken confidentiality extremely seriously, and it was a textbook example of best practice in protecting trade secrets. And given the increasing mobility of specialist employees in the tech sector, what else can organizations do to mitigate the risk of trade secret misappropriation? First, we recommend that you ensure confidentiality and trade secrets are covered in employee induction training, and as well as part of regular ongoing compliance training. Second, it's more important than ever to make sure that you do have robust exit procedures in place. In the Playtech matter, although there were password protections on the platform, Playtech failed to revoke the developer's access when he left. Revoking access rights should be a standard part of any exit process, and where highly sensitive material is involved, should even be considered earlier during an employee's notice period. And in our experience, exit interviews are often the place that clients say they first suspected that something was amiss about an employee's departure. Courts will also generally expect to see a clear framework of contractual protections in place, strong confidentiality clauses in employment contracts, specific NDAs covering particular projects, and contractual obligations requiring confidential material to be returned or destroyed on exit.
So on to our sort of final trend. As mentioned earlier, there was a considerable uptick in trade secrets litigation in 2025, and particularly in the US. So far as we can see, this is at least partly, if not predominantly, being driven by AI. Everyone's been talking about how trade secrets can protect valuable, non-patentable AI assets like algorithms and data sets and training methods for some considerable time. But I think it's fair to say we're only just starting to see this type of claim really starting to progress through the court system. And to understand the full extent to which companies are relying, whether partly or wholly, on trade secret laws to protect their AI innovations. So one of the first AI trade secrets cases featuring the major players was commenced last year in the US by xAI against OpenAI, concerning their respective models, Grok AI and ChatGPT. X has alleged that OpenAI intentionally recruited several of its employees in order to access and take advantage of its trade secrets in the Grok AI model, and in order to gain an unlawful advantage in the further development of ChatGPT. The trade secrets in question included what was referred to in the claim documents as xAI's secret source, that is, its operational process for rapid data center construction and deployment. What is particularly notable is that X is presently hanging its hat solely on trade secrets and unfair competition laws. In fact, such is their reliance on trade secrets, X's complaint states, and this is the quote in the slides, trade secrets protect nearly all of xAI's developments, model weights, training data, tuning methods, know-how. And its ability to rely on trade secrets is critical not only to its competitive position, but its ongoing operations. Procedurally, this case is at very early stages, so we're going to have to wait to see how this one plays out. But for today's purposes, we did just want to mention that X has necessarily needed to plead all of the ways in which it's kept those innovations or attempted to keep those innovations secret. So they conduct security awareness and data handling training for their employees and give them regular spot tests. They perform background checks on new recruits. They adopt endpoint security on employee devices. They have formal written information security and confidentiality policies, in addition to specific employee NDAs with confidentiality and security obligations. However, even with all of these incredibly sensible measures in place, threats from competitors can still take shape in unpredictable ways.
Yeah, and we saw this last year in a claim filed in the US by a company called OpenEvidence. OpenEvidence had developed a highly successful generative AI chatbot, which was trained on medical data and research, and it was designed to support medical professionals in making clinical decisions. One of OpenEvidence's competitors, Doximity, decided it wanted to launch a competing product. And, on OpenEvidence's case at least, Doximity came up with a good shortcut. It created fake accounts to access OpenEvidence's chatbot by pretending to be medical practitioners, and then it used injection prompts to ask the chatbot to reveal its system prompt code, its algorithms, and other of OpenEvidence's trade secrets as to how the system worked. You can see just two examples of the prompts that Doximity used on the slide. Eventually, the very capable and well-trained AI chatbot did exactly as it was asked to do. It responded by disclosing the information requested, and in doing so, had revealed OpenEvidence's confidential information and trade secrets. Now, OpenEvidence alleges that this is a coordinated cyber attack designed specifically to circumvent its security measures and reverse engineer confidential features of a model that it had spent years and millions of dollars developing. Doximity, for its part, says that although attempts were made, they didn't actually obtain the full system prompt, meaning there can be no finding of misappropriation. We'll see how these arguments play out in due course, but the broader question that we've been considering is this. Can the steps OpenEvidence took to protect its trade secrets really be deemed adequate to maintain secrecy if the chatbot could be so easily manipulated into revealing any of that information? OpenEvidence maintains that it did implement technical safeguards to prevent this kind of reverse engineering, but plainly those measures didn't fully succeed, so were they enough? Since reverse engineering is not prohibited in many jurisdictions, it's crucial that contractual restrictions against this type of exploitation are incorporated into terms of use for any publicly available product, whether AI-driven or otherwise. This should go some way to support a claim that steps have been taken to protect the secrecy of the confidential information underlying a product, and at least gives the option of a separate claim for breach of those contractual terms. This case is yet to go to trial, but it'll be really interesting to follow how these sorts of issues are addressed.
So we hope you found that overview of the latest developments interesting. And to wrap up, we've just put a summary of our recommended best practices and reasonable steps in summary on this slide. And even if they don't prevent misappropriation in the first place, they should at least put you in a good position if you need to take action. We wanted to just leave you with one parting thought. It is important to bear in mind that the notion of reasonable steps a company is required to take is flexible, and the standard does differ depending on the resources available to the trade secret holder. Also, the standard is one of taking reasonable steps in the circumstances, which means trade secrets policies, practices and procedures need to evolve with your innovations and in response to changing security threats. For example, in the XAI and OpenAI case, which we've just spoken about, one of the ways in which the source code was allegedly taken by the departing ex-employee was through AirDrop, from their work phone to their personal iPhone. AirDrop, as you know, is almost instant and it can be very difficult to trace. This is a very different proposition to when I first started litigating these cases 15 years ago, when we were primarily concerned with downloads onto portable hard drives. So while trade secrets can be a hugely effective way to protect valuable assets, they can be made vulnerable and need to be closely monitored and guarded.